All right. I think we have enough folks who has joined. Everybody can hear me okay?
Yes, we can hear you.
Okay, great. So welcome to the webinar. So today we're going to talk a little bit about H-1B modernization, the new rules that's going to go in effect starting January 17, 2025. And also we're going to talk about the impact of the Trump administration on immigration. Some items that we're going to talk about is first of all these two, and then we're going to not take any questions during the presentation. You can type in all your questions in the chat, and then we will take those questions towards the end. If we do not get to the questions, we can you can send it to us on the email at info@vkmlawgroup.com. So with that, I know we only have an hour, so I'm gonna pass it to our attorney, Vinay Malik. Vinay, you can take it from here.
Thanks, Kalika. Good afternoon, good morning, good evening, folks, wherever you are. I know we have people from all over the world joining this very important discussion. So thank you for your time, and hopefully this presentation will be of value to you. So let's get started. I think, Katrina, I think there's some issue with the presentation. I'm seeing only half the slide. Okay. All right, there you go. So a little bit about our firm. This is what we do. Most of you are probably aware. Our firm specializes in business immigration. These are some of the visa types we work on. We also do help with I-9 and E-Verify compliance, so on and so forth. So, these categories are self-explanatory, so I won't get into them. Obviously, we are going to delve a little bit into the H-1B category because there's some very important updates that are being made to the H-1B program. And we'll talk about that in some detail in the second half of the program. Right, Katrina, can we move on? A little bit about myself. I'm the principal attorney at VKM Law Group. I used to be an engineer before I became a lawyer. And there's just some information about myself. I used to litigate in federal court prior to getting into transactional practice. Can we move on? So, as we all know, President Trump will take office on January 20th. Immigration was a big plank in his campaign. And after he won the election, all the polls show that the voters who voted for him really want him to quote unquote reform US immigration. So we can expect a lot of changes on the US immigration policy, including rules, regulations, and maybe even some bills being passed through Congress. Now, we also have the benefit of President Trump's first administration, right, from 2016 through 2020. So we have some idea of the types of policies he would like to implement. And we have, again, some experience in what we had to deal with in terms of the rules, regulations, and also adjudicative policies his administration implemented, some of which the courts struck down, but some of which remained. All right. So we'll get into a lot about what we can expect in the next 4 years, essentially starting from January 20th. Okay. You move on. So, as a lot of you may remember, the previous administration, the previous Trump administration, the day that he took office, right, he implemented a travel ban on predominantly Muslim countries, which was subsequently struck down by the federal courts. But it did lead to a lot of chaos at the airport, as you can imagine. There was an increase in the processing times for pretty much all visa types. Denial rates went up. there was an increase in auditing of cases, meaning if a case was approved, it was then sometimes audited. And if USCIS or DOS did not like what they saw, they would revoke the approval. There were a lot more compliance visits, right? And overall, it just led to a lot of agony in the immigration community. And pretty much it was just a tough going, right, for lawyers and their clients. Um, Regarding the H-1B, some of the things that took place were there was an increase in the H-1B wage levels. That increase was subsequently again struck down by court, but again, it was an attempt by the administration to quote unquote reform the H-1B program by increasing the H-1B wage levels. And there were some proposed changes to the H-1B cap lottery. One of the changes that was proposed by the Trump administration was to give a preference to those with PhDs, right? Um, in their background. So if anyone had a PhD, they had a higher chance of getting picked. Now, some of you may have heard about the recent debate on the H-1B program where Elon Musk and some other politicians and media pundits weighed in. And there is a lot of talk about the H-1B program being reformed in some shape or form, right? So I predict that the wage levels may go up for H-1B cases, meaning if you have wage levels 1 through 4, there may be a policy decision or even a rule saying you have to pay an employee at least the median wage, right, in that occupation for that geographic location. So we can expect those kind of changes to be brought back once the new administration comes in. Katrina, can you move on to the next slide? So what do we expect? There will be increased scrutiny of cases, and that will almost surely lead to higher denial rates, right? Why will there be increased scrutiny? Because again, it's a policy decision. A lot of administrations, their offices, they set certain quote unquote thresholds, like, we only want to see an approval rate of X. So do your best to stay at that rate. And how does that happen? There's increased scrutiny of cases, there's increased demands for documentation. Every statement needs to be corroborated. And if you don't do that, the case will likely be denied. Now, the one thing we all have to keep in mind that immigration is a benefit, not a right. What does that mean? It means the burden of proof is on the petitioner or the applicant to prove that that person qualifies for that immigration benefit, right? So the burden of proof is again on us. And again, it might be more difficult to satisfy the burden of proof under the Trump administration. So I'll give you a quick example, right? We file an H-1B case at a level 1 wage, which is allowed under the rules. But if the title of the position says senior software developer, I've seen RFPs during the Trump administration saying, well, the title says senior, how can it be a level 1 wage? Shouldn't it be a level 3 wage or level 4 wage? Another example is if, for example, uh, the experience requirement, for a particular position, if it's anything over 2 years for a job zone 4 occupation, we can expect an RFE saying, well, your experience says, the job requirement says 4 years of experience, it can be a level 1 wage, right? So that is a correct analysis under the rules and regulations. How do they do that? By just scrutinizing the petition for a little bit longer, right? So we got to be really careful in how we prepare the petition. And remember, once we prepare and file the petition, you really can't take it back, right? You can't say, well, that's not what I really meant, because again, then you're, treading into dangerous territory. So we really need to have very thorough documentation and file as early as possible because we know that processing times are going to go up, right? Next slide, Katrina. On the green card front, we can expect to see more cases being audited by the Department of Labor, meaning An audit in the perm world is equivalent to to a request for evidence in the H-1B or L-1 world. So we can expect more and more cases to be picked up for audits. And what does that mean? It really means that we prepare the job description properly, we run the ads correctly, we keep all the documentation on file, and we be ready to support our contention to the DOL saying that there are no qualified US workers, right? So again, expect increased audits, there'll be increased scrutiny, and we also expect the denial rates for green cards to go up. Because again, they'll just be asking for more and more evidence. And if they see the slight bit of inconsistency between what we said on page 1 and what you say on page 10, they're going to say, look, you really haven't met your burden of proof, and we're denying your case, right? So again, be ready for that. Next slide, please. A lot of people have been asking me about travel bans. Now, travel bans were a big thing in the first administration. We've all heard about it. And the question is, will there be a new set of travel bans? From what I understand and what I've heard through the grapevine, there will be some travel restrictions in place targeting countries that are not quote unquote friendly with the United States. The nature and extent of these travel bans remains to be seen. Here's what I would recommend though. If you have non-citizen friends and employees or family traveling outside the US, it may not be a bad idea for them to come back by January 20th, because any sort of travel ban, if implemented, is going to certainly lead to chaos at the airports. So it's better not to get caught in that chaos. In the subsequent slides, I'm going to give you some options as to what you can do should you be caught in a bind at the airport. We'll get to that, but to the extent possible, try and avoid flying into the US anytime between Jan 20th and maybe the end of Feb, unless you're a US citizen, if you can help it. We do expect denials at the consular posts to go up and also at the airports. As we all know, even if you get a visa to enter the United States, the Custom and Border Patrol officer has a right to turn you back if he or she thinks you do not qualify for the visa you're using to enter the US. So be careful about that. Another question that has a lot of people have been asking about this, what's going to happen to the student visa program? So, a lot depends on how President Trump, you know, who he listens to, right, on this. If he's going to listen to the really hardline folks like Steve Miller, who is his deputy chief of staff, we can expect an attempt, at least, to shut down the OPT program for the F1 visas and the EAD programs for H4 holders. Now, will there be litigation against any such attempt? Absolutely. I expect the universities and a lot of other organizations to fight any such attempt to shut down these programs for sure. But we can see that, I mean, there is a likelihood that some attempt will be made to curtail these programs in some shape or form. Again, it really depends on who President Trump finally ends up listening to within his circle of advisors. Next slide, please. Compliance and enforcement. I touched on this a little bit. Let me reiterate this. There will be a heightened enforcement on visa compliance and I-9s. What does this mean? Once you get the visa, you're not out of the woods. You can expect visits, site visits from Department of Labor and Department of Homeland Security and Department of State to make sure that you are complying with the terms of your visa. And I'll get into a little bit of what that will look like at least on the H-1B front later on in the webinar. But just expect more site visits. And there could very well be a push for all employers to enroll into the E-Verify program. Right now, the E-Verify program is mandatory. It's only required for certain employer types. For example, if you do any sort of business with the federal government, you are required to be E-Verify compliant and enroll in that program. There may be a push by the new administration to ensure that every employer, regardless of their size, um, enrolls in the E-Verify program. And obviously that is going to lead to an increase in cost, right? Because you need to spend money to be able to get into these programs and stay compliant. But again, this is something you want to be aware of. Next slide, please. So proactive measures, right? What can companies do to try and, avoid getting caught in this immigration quagmire? So some of the companies tried doing this 8 years ago. They try to set up nearshore offices in countries in relatively the same time zone, like Canada, Mexico, Argentina. But again, the political situation in these countries has also changed in the last 8 years. So it may not be as easy to, get qualified foreign talent in these countries today as it was 8 years ago. But again, that's an option you can look at. Obviously, for your US foreign workers, you got to prepare thorough documentation, not only for the petition, but then you need to maintain appropriate documentation for these compliance visits that you can expect from DHS and DOS officers. Uh, I get a lot of questions from DACA and TPS holders. For those who don't know what DACA and TPS are, these are temporary work permit programs. DACA is really for the people who came here as minors. They came in illegally, but they were young. They came in with their parents, or they came in unaccompanied. President Obama came up with this program to give them work permits and let them stay in the US. We can see some attempts by the new administration to curtail this program. TPS, President Trump has already signaled his intention to end TPS, which is temporary protected status, for citizens of a lot of countries. These are typically countries that are affected by natural calamities or political strife, like Venezuela, Colombia, so on and so forth. There may be an attempt to shut these programs down. Now, again, there will be litigation, I presume, but again, even though there will be litigation uh, around all of this, it does, you know, put these programs into question marks. So what I recommend to people on these different statuses is to try and see if they can get some other type of non-immigrant status. So for example, if you have, a technician or an engineer who has TPS or DACA, try looking at the H-1B program, right? Or the H-2B program or something like that to see if you can get them some other non-immigrant status or even start their green card process, right? By filing their perm. And if some people are very highly qualified, you could look into filing an EB-2 NIW green card or an EB-1 green card, right? Which does not require the perm. So you need to start looking at alternate options now so that when, things really, go bad, you're not looking for options at that time. It's better to have a backup plan, now. I cannot stress enough, you need to have competent immigration counsel at this time and during these years because there will be a lot going on. We can expect policy changes happening almost every other Friday afternoon. I mean, that's typically when USCIS publishes a new policy. It's at 3:30 p.m. on a Friday afternoon, and that can really ruin your weekend. So it's really nice to have some competent immigration counsel besides you who can hold your hand and make sure you're doing okay. Next slide, Katrina. So consular processing, this is going to be a very interesting situation. Consular posts, some consular posts are really notorious. They have a very high denial rate. And one thing to keep in mind is it's very difficult to appeal an adverse decision from a US consulate. Very difficult to appeal that, right? So what do you think is going to happen, or what do I think is going to happen during the Trump administration? And I'm not the only one. A lot of immigration attorneys, we expect the denials at the embassies to go up. Why is that? Except for a couple non-immigrant visa types like the H-1 and the L-1, every non-immigrant visa applicant is presumed to be an intending immigrant, which means the burden of proof again is on the applicant to prove that he or she will not obtain permanent residence in the United States. The burden of proof has always been on them, but now we expect a much more stricter application of this burden. So, for example, here's the hypothetical. You have you live abroad, you have a child, a US, a foreign child on an F1 visa, which is a student visa, studying at a US university. It's graduation time. It's May of 2025, 2026. The parents want to come and attend their kid's graduation. Can their B1, B2 visa be denied? Whereas, 2 years ago, it wouldn't have been. Very high chance because, I can see a consular officer saying, well, both your kids are studying in the US. I think you're going to come and just live here and you're just using the graduation as a pretext to enter the country. And if you get denied, again, it's very difficult to overcome those decisions. So what do? You need to prove strong ties to your home country, right? You need to prove that you have a business, you have a job, you have property, you have old parents or an ailing relative that you need to take care of, which can convince the visa officer within 5 minutes, because that's pretty much how long an interview lasts, that you will come back to the country, right? So again, it's something to keep in mind and prepare well for your interview. Next slide, please. All right, so I touched on this earlier. We expect a lot of chaos at the airports if any travel ban is implemented. So you come into the US, you have a valid visa or ESTA, depending on the country you're coming from, and the CBP officer decides to detain you or turn you away. Who are you going to call? Not Ghostbusters. They can't help you over here. You got to call an immigration attorney. A lot of us, depending on where we practice, we have relationships with the Custom and Border Patrol officials at the port of entries near our offices. So, for example, I may know some CBP folks at JFK or EWR, right? This is the time those relationships help. Now, you are not entitled to an attorney at the CBP checkpoint because you haven't entered the United States. You haven't gained lawful entry. But if you make a call to your immigration attorney, your attorney calls the CBP supervisor, there is a chance that they'll at least listen to the attorney, right? And the attorney can help you make a case. Does the country of origin or citizenship matter? It absolutely does. I hate saying it, but it does, right? So we can expect certain citizens or citizens of certain countries or people flying from certain airports being subjected to a higher level of scrutiny as opposed to others. That's just a fact of life. So be ready for that. Are some point of entries better than others? Absolutely. So consult with your immigration attorney if you intend to travel anytime between Jan 20th and say the end of Feb to try and determine, just based on our experience, we know that certain airports are more amenable to foreigners as opposed to others. So it may not be a bad idea to talk to your attorney about such plans. Katrina, can you move on, please? So in summary, you can expect restrictive policies to be put in place. Look, this was the huge immigration plank on which President Trump ran. And many think that this is one of the biggest reasons he won the election. So do expect a certain level of upheaval in US immigration. I think it would be naive not to expect so. The extent of that upheaval remains to be seen, and we can hope for the best, but it's not a bad idea to stay ahead and do what you can to plan. Can we move on? Excuse me. All right, H-1B modernization rules. In an attempt to try and prevent President Trump from really dialing back on the H-1B visa program, President Biden's administration has promulgated a new set of rules which will be effective January 17th. Now, these rules were in the making for the last couple of years. They went through posting, the public comments, when every time a new rule has to be taken into effect under the Administrative Procedure Act, the rule has to be posted for public comments. The agency receives those comments, it analyzes them, and then it publishes a final rule, which may be different in some ways than the initial rule they published, and they try and address all the comments that they received. So the Biden administration did that for the H-1B visa program. They published the rule, the final rule on December 18th, and the rules are effective January 17th, which means in about a week from now, week or 2 weeks. And just keep in mind that anyone filing for an H-1B on or after Jan 17th has to use the latest I-129 form, which will be available shortly. So please keep that in mind. So let's get into these rules. They're really interesting, and I think it'll benefit everyone to hear about them. So under the new rules, there still needs to be an employer-employee relationship, and what the rule did is it codified who a U.S. employer is. And according to the new rules, an employer is someone who supervises the work of the H-1B employee, who states where the work will be and shows that that employer, and this is or, so you either supervise the work or you define where the work will be, or you have the ability to hire and fire that employee. This becomes really important in third-party placement situations. Um, Especially for staffing companies, because typically in a staffing company you're not controlling the actual work of the H-1B employee, but you do have the ability to hire or fire the employee, and you really need to make sure you document that very clearly. I typically advise clients to also show some level of control over the employee's work, even in a third-party staffing situation, because again, they could try and bend the rules a little bit, or make the adjudication policy to make that look nebulous and start asking for that side of documentation. So it's not a bad idea to have some, evaluation reports, project status reports filled out, periodically by the employee, even in a third-party staffing situation. And this is really important. You have to show that that H-1B employee will remain your employee for the 3 years, right? For the entire validity of the petition. So again, you got to have sufficient documentation to prove that. Next slide. Specialty occupation criteria. This was a welcome change. So under the prior regulations, an occupation pretty much had to have 1 or 2 degrees that could work for it. So if it was a software developer position, the beneficiary needed to have a degree that was directly related to that position, right? Directly. Now, what does directly mean? So directly was very restrictively construed by the agency. It had to be directly, like, just a couple of degrees could really work. Could be a computer science, computer engineering, or maybe electrical engineering, nothing else. Well, times have changed, especially with AI and ML. You have a lot of allied degrees like robotics, data analytics. And really, those degrees can still be applicable to a software developer depending on what the project is. So, what USCIS has said is that there needs to be a logical connection between the degree and the actual job duties. So, a wider range of degrees will be acceptable. They also clarified what the term normally means. So, the rules say that a degree has to be normally required for that occupation. Now, prior administrations, including the Trump administration, said, look, if any publication says that a software developer position typically requires a bachelor's degree, typically is not normally. So, you know what? It's not a specialty occupation position. Well, under the new rules, they've removed this ambiguity and they're saying, look, right? Normal means typical, it does not have to be absolute. So if 90% of the positions in the software developer, if 90% of the software developer positions require a bachelor's degree, it is a specialty occupation position, that 10% notwithstanding. All right, so this is a welcome change. Next slide, please. So this was an interesting rule. USCIS says, look, we have the authority to enforce the conditions of the labor condition application. Now, for those who are familiar with the H-1B process, you know the Department of Labor issues the labor certification. So there was a lot of back and forth, and a lot of immigration attorneys, including yours truly, feel that DHS does not have the authority to enforce the terms and conditions of an LCA. USCIS took a different position. They said, no, we really do. So they are really going to make sure that everything in the I-129 petition corresponds with what's in the LCA. Now, it makes logical sense anyways that when you file the I-129 petition, you make sure everything aligns with each other, but just make sure that you really do, because this time around, if there's any sort of misalignment, right? Either the job location is different, or the job title is different, or the salary is different, right? It can result in not only a denial of the petition, but if a petition was previously approved and then there's a site visit and they find out that the beneficiary is not working at that location or is not performing job duties consistent with their occupation or isn't receiving the salary consistent with the LCA, even a DHS site visit can result in the revocation of the petition. Right, next slide. Now, this is going to really impact third-party staffing companies. USCIS has codified the requirement that the employment has to be non-speculative, meaning bona fide, right? It has to be available at the time of filing. Now, this is really interesting, and this tells me why no one who works at USCIS ever worked in the real world, right? I mean, I don't know any employer can actually say that, yes, I have a position open in March of 2025, and I'll keep it open for this beneficiary, assuming he or she gets picked in the lottery, gets their H-1B approved, gets through the consular interview, and is ready to come to the US and will be here sometime in December. It absolutely makes no sense, but that is what USCIS is saying. All right. Now, what kind of evidence can you prove? Can you provide? Um, you can provide MSAs, work orders, and also a client letter. They are going to require some, if it's a third-party staffing situation, you need to get some sort of evidence from the end client that that position exists. Now, a lot of employers, what they try to do is they try to show in-house employment for the time being. Like, look, we have some projects going on and this person is going to come here because in all honesty, you don't know who the end client is going to be, and no end client is going to give you a letter. To that end, what USCIS has said is if you, as a third-party staffing company, say that you have in-house projects, you need to have some sort of a track record in developing projects, software or products in-house. So I think it's going to be really, really interesting for third-party staffing companies as to how they deal with the non-speculative bona fide employment requirement. Next slide. So this is a welcome change. There are a lot of entrepreneurs who want to start companies, but they really can't be employees of the company, so they can't get an H-1B filed for them. So what USCIS has said is, look, if an H-1B beneficiary either is a majority shareholder or owns more than 50% of the shares in the petitioner, that's okay, right? That company can still petition for that H-1B employee, but the initial petition and first extension will be limited to 18 months each, right? And why is that? They still want to make sure that employer-employee relationship exists. And you still have to prove that even if Vinay Malik is the majority shareholder of VKM Law Group and VKM Law Group is petitioning for Vinay Malik, he's still an employee. So you need to have, something like a board that controls his employment and has the ability to hire or fire, right? So it's additional work, but it can be done, but it's necessary to still show that the H-1B employee, H-1B beneficiary is an employee of the petitioning company. Next slide. Um, Again, this one is specifically for third-party staffing. The requirements for the position have to come from the end client, not the H-1B petitioner, not from a mid-vendor, not from a prime sub-vendor, the ultimate end client. How do you get that? You get that from a client letter. If not client letter, try and get an email from the end client, have job ads from the end client that are compliant, or affidavits from coworkers at the end client or supervisors, or even some sort of project documentation from the end client showing the complexity of the work that needs to be done. Now, Regarding project documentation, a lot of it, there might be some confidential information in the project documentation. USCI says, and rightfully so, it's okay to redact confidential information, but you cannot heavily redact a document such that it is rendered meaningless, right? So be careful about that. Okay to redact, but within limits. Next slide, please. Cap exemption adjustments. So under the previous rule, obviously, if a nonprofit or governmental research organization was petitioning for an employee, um, that petition was cap exempt as long as the research was the primary mission of that organization. Now we all know that that's really not the case. A lot of hospitals, right? They do research, but their primary care might be patient care, and as a result of that, they do research. So what USCIS has said is that as long as you can show that the research is a fundamental activity of that organization, they're still cap exempt. In the previous rules, if you as a third-party staffing company were placing an employee at a cap exempt organization, that petition would be cap exempt as well, as long as that employee was working at the site of that cap exempt organization. They've changed the rules now, and they've said that as long as the H-1B beneficiary is providing at least 50% of their time to support the fundamental purpose of the qualifying organization, they can qualify for a cap exempt position. So it's gone down from 100% working at the cap exempt organization to 50%, right? So that's a welcome change. Next slide, please. Now, this one is really important. There have always been site visits from FDNS officials, and it was cooperation with those officials was always voluntary. Not anymore. USCIS has codified its authority to conduct site visits. If you choose not to cooperate with the USCIS officers, it can lead to an automatic revocation or denial of the visa. Now, there's one thing I want to emphasize here. Yes, you need to cooperate with these officers, right? But you don't have to accede to each and every request if those requests are too broad. So if an FDNS officer comes over to your site and says, look, I need the payroll records for Vinay Malik because I'm reviewing his petition. Okay, you can provide those payroll records. But if the officer says, and by the way, I also need the payroll records of Jane and John Doe. Well, why? You don't need to provide them because they're not the subject of the site visit, right? So you got to be careful about what documentation you provide to them and what not. Now, many a times officers will, provide some very unreasonable demands and put some very restrictive deadlines. I need everything by 5 p.m. today or tomorrow. Not necessary. This is the time you contact your immigration attorney, let him or her deal with the officer. We typically can get some more time to respond to these requests. And it's really important that you review the information you provide to them because they're not your friend. And again, any inconsistency between what you tell them and what's in the petition can lead to a denial or revocation. So you got to be really careful. Next slide. So this is a welcome change. A lot of you have heard of the term cap gap as applies to the H-1B program. So if there's a student on F1 status, on OPT or STEM OPT, and if their OPT status was going to expire, um, anytime while their H-1B petition was pending, they could use cap gap. Cap gap allows them to continue working past the expiration of their OPT until September 30th of that year. Well, we all know that sometimes H-1B petitions don't get adjudicated by September 30th. We file them by June 30th. I've seen them get adjudicated in Jan or Feb of the following year. So cap gap is now extended until April 1 of the fiscal year. So you file for a F1 OPT student, you file their H-1B in May of 2025, and if say their OPT status expired in June, their cap gap will now let them work through April 1 of the following year, April 2026, unless their petition is adjudicated prior to the cap gap. All right. So So this avoids gaps in lawful presence and employment. Next slide, please. Here's another important uh, codification. And this is something the Trump administration did not want. And they actually had a policy memo contrary to this, where they said we will give no deference to any prior adjudication of a case. What the Biden administration has done is they've codified that policy into a rule saying adjudicators are supposed to give deference to prior adjudications of Form I-129 when the same parties and same facts are involved, right? So you file for Vinay Malik's H-1B, it gets approved. Now you're filing for an extension or an amendment. You're the same employer, same petitioner, same beneficiary, same, occupation, relatively same salary. If it was adjudicated favorably the previous time, it will be it should be adjudicated favorably even now. And this includes also change of status and amendments, okay? Unless there was a material error in the previous petition, which they did not catch, or there's a material change. So Vinay Malik was a software developer, now he's a computer system architect. So the facts have changed a lot, right? There's a material change, the occupation has changed. In that case, they may be allowed to adjudicate the petition anew without giving any difference to the prior adjudication. But absent such circumstances, they should give deference to the prior adjudication. Next slide. So overall, between the H-1B modernization rules and the incoming administration, I think employers should be ready for increased costs and an increased impact of compliance on their operations. They really should gather additional evidence to support petitions, and you really need to prepare for potential site visits and have the documentation handy so that you can adhere to any reasonable time limits imposed by the officers who conduct such site visits, including visits to people's homes. So again, another thing to keep in mind is if you put a home address on an LCA, you are opening the doors of your home to the USCIS officer. If you want the benefit of working on H-1B status from your home is now an H-1B, it's an LCA certified work location, and you need to be compliant while working at home as well. And officers can therefore knock on your door and check to make sure you have, a workspace where you can do your work. Next slide. I think that was it. I tried to stay within 45 minutes so that there was some time for questions. If you have any questions, feel free to put them in the Q&A box. We will end the seminar at 3 p.m. I know there are folks from Mexico and Europe who are in different time zones, so they need to be able to sign off. To the extent your questions could not be answered now, feel free to email them to us. Here's our contact information, and we'll try and respond to your questions as soon as possible. So, Katrina, do we have any questions?
From Gopi Ravuri, after visa approval, the site visit happened to me.
So, what's the question?
I think he is just mentioning that after his visa approval, a site visit happened to him.
Yes, so that will happen. So be ready for that, right? As I said earlier in my presentation, even once the visa is approved, you're not out of the woods, right? As long as the petition is still valid, USCIS and the Department of State have the right to conduct site visits and make sure that you are compliant with the terms and conditions of the H-1B petition.
Okay. Next question is there anyone in Trump's team or advisors with a positive stance on the H1 or H4 EAD programs? Will H4 and H4 EAD applications be approved together under the premium process if filed concurrently after January 17th? What will the cap registration fee be for 2026?
All right, so these are three questions. So I'll try and answer all three of them. Um, there are people with more reasonable points of view in the current Trump administration. You have Elon Musk, you have the Cantor Fitzgerald guy, all the Silicon Valley tech guys. And then on the other side, you have the hardliners like Steve Miller and Steve Bannon and that, right? And their position is very clear. You can read all the white papers Steve Miller has written, and you'll know exactly where he stands from. And I think there'll be some middle ground over here, right? So there will be some changes to the H-1B program, I think. I I personally think wage levels will go up. There will be an attempt to increase the wage levels. There may be an attempt that only people with certain degree types they get a preference. It all remains to be seen. So that was the first question. The second question was, will H4 and H4 EAD applications be processed concurrently with H1Bs that are filed under the premium processing program? So under the Edakuni settlement, that was only for a surety until Jan 18th. What will happen after that is something that remains to be seen. USCIS has not taken a position one way or the other. Again, if it's a Trump administration, they'll probably say no. They need to scoot again because they're going to try and slow down everything to the extent they can, right? They're saying, look, you're paying for premium processing for the H1, not for the H4. And I think the third question was whether the EAD program will survive. Was that the third question?
The third question is what will the cap registration fee
Fee,
for
right.
2026?
Um, yeah, so it's going to go up. I think the under the latest fee increase, it's $215 for each registration. So
All
unless
right.
something changes, that's what it's going to be,
Mm.
$215.
All right. So that's the answer for the question for Pavan. Next question is perm have been processing since 16 months. Any time frame of when they can be approved, or are they held up waiting for a new government?
Well, it's only going to get worse under the new government. So under the current processing time, so here's the thing. The Department of Labor has certain priorities, okay? They get funding from the government. Um, they're not funded by the clients, meaning people who apply for benefits, right? They get all the funding from Congress. And they have certain programs that they are mandated under law, under statute, to adjudicate within certain timeframes. For example, the H2A and the H2B programs, right? So whenever they're under a crunch, they put their resources towards these programs, which they absolutely have to adjudicate within a certain time frame. So who bears the brunt of all of that? It's the programs like the PERM, right? So yes, current processing times are really high, 16 months. Absent the Department of Labor getting money directly from applicants, like USCIS does, I don't think that's going to change, right? Um, or unless Congress gives them so much more money that they can hire people, like, a lot more people, a lot more workers to adjudicate. Because remember, USCIS used that as one of the reasons for increasing their fees. They said, look, you want reduced processing times, you want more competent adjudications, give us more money so we can hire more people and train them. So DOL doesn't have that. So that's, I think, what the problem is. What's the next question?
Next question is what if an H1B transfer gets rejected while the grace period is still due and vice versa?
Okay, if it's rejected while the grace period is still due, if you're within the 60 days, you can always file another petition. Vice
Okay.
versa. If it's denied after the 60 days, then you're accruing unlawful presence, and you should do something within 6 months, either file another non-protunct or leave the country or do something like that. But remember, if your 60 days have expired and your transfer petition is denied, you could be accruing unlawful status.
Okay. And then next question is should we anticipate rise in the minimum wage under the Trump administration? How will this impact current wage levels, specifically that the level ones are already at rise?
Yeah, I mean, Again, I really can't say anything for sure. I'm not in the administration. Um, I, just from past experience, can expect that. Also based on, the statements Mr. Musk has made, what they will look like, I don't know. And I understand that, for certain regions, even level one wages are really high, like the Northeast and the Mid-Atlantic. And, just a it's an indication of the times we are in. I would look at alternate occupations for that H-1B to see if we can slot them into a lower wage.
All right. And next question is, do we need to file an H-1B amendment if an employee moves within the applicable commutable distance of the address listed on the LCA?
No, you don't. So under the matter of Simeo, which by the way has been codified in the new rules, you don't, as long as you're within commuting distance of an LCA location that has been certified. The key though is when you change locations, just repost that LCA at the new location for 10 business days, right? At two conspicuous locations for 10 business days at the new location, and keep a memo to that effect in the public access file of the H-1B.
All right.
Important.
Another question, I think this is a continuing question. Is there a possibility that the H4 EAD program will be discontinued during Trump's tenure? Will the premium process be implemented for H4 and H4 EAD petitions?
So I spoke about the second question, right, or the
Mhm.
second half of that question. Will there be again, if Steve Miller has his way, absolutely. There will be an attempt to kill H4 EAD. It really depends on who President Trump listens to last. It's
All
only going to
right.
come down to that.
Okay, we still have a few more questions. The next question is, what are the new specific changes expected in relation with the current H1 approval process? I don't see anything new and specific in the presentation. Can we just elaborate this?
So again, then I think if it's a third party placement, there will be a request for evidence from end clients to show that the job duties require a bachelor's degree in that field. So that's really important. The second thing is, again, this affects third parties more than anyone. If you say that you have, third party staffing companies, if you say you have an in-house project, they're going to need more documentation about that project. They want to see some track record you've had, about, what have you done? What software have you made? Because, we see you as someone who services other clients. So what project are you talking about? What did you do in the last 2 years about it? Show us a business plan, show us your rate of return, stuff like that. The other
Mhm.
thing is this LCA enforcement. So, let me try and elaborate a little bit on that. Let's just say it's a change of employer, okay? H-1B, a transfer, it's called a transfer case. I expect RFEs now from the USCI saying, okay, this is an H-1B employee, Mr. Vinay Malik, working as a software developer, and he is seeking a change of employer, which means he's already on H-1B status, right? Please give us his W-2s and pay stubs for the last 3 years because we want to make sure that he was compliant with the previously filed LCA, the LCA of his previous employer. Because if not, then he isn't maintaining status. And if he's not maintaining status, we won't approve his change of employer and extension of status, right? Now, think about this. I'm applying for a new job with you, Katrina. USCI has issues an RFE to you saying we want all the W-2s and pay stubs, not for just for the last 3 months, which is the norm right now, but for the last 3 years of Mr. Malik to make sure that he is compliant with the LCA terms and conditions of his previous job. Now, you as a new employer don't know what those terms and conditions were. You don't have a copy of the LCA for the H-1B that was filed by my previous employer, right? So you are flying blind. And if for whatever reason I was not paid my H-1B wage at any time during those last 3 years, they could deny the petition. Does that answer people's question?
I guess.
Okay, I hope so. If not, they can ask for a clarification. Otherwise, I just need to check on the time. Okay, we have
We
a
still
couple more
have two
minutes.
minutes. We
Okay.
still have 2 minutes. The next question might be the last question is, as an employer, we have filed for H-1B transfer and there has not been any approvals or RFE since last 5 months for two of our candidates. What do I do?
Well, I mean, you just have to check and see what the processing times for that service center are. If they're outside of processing times, raise a service request and,
Mm-hmm.
they'll respond. Um,
Okay.
so that's pretty much it. Or if you're in a hurry, premium process, pay an extra 2805 and you'll get a decision in 15 business days.
Mm-hmm. Okay. Next question is, are there any impact to H4 EAD and H4 standing in India?
Sorry, can you ask the question again?
Are there any impact to H4 EAD and H4 standings in India?
Stampings in India. Okay. Again, under the Trump administration, we can expect greater scrutiny for any kind of visa interview, right? So for an H4, they might say, all right, make sure, are you married to this person? Is this person really working? Show us their paperwork. You want to make sure they're getting paid what they were supposed to get paid under the H-1B. So that's the kind of additional scrutiny one can expect at the US Embassy abroad for H-4s. EADs don't come under the embassies. EAD is a benefit provided by USCIS, right? So in terms of increased scrutiny of the EADs, I can't think of anything in particular at this time, except you have to prove that you are in status, you're in valid H-4 status. But the EAD program in itself may be on the chopping block, depending on who President Trump listens to at the end.
Okay. I think we still have few more questions, but we are already in time. Vinay, do you wanna end this?
I'll just take one more question, and then
Oh,
the rest, folks can. Again, I want to be mindful of everyone's time. It's really late in Europe.
yeah. Okay, the last question we can have is, do you think the new Trump administration policies will impact talent acquisitions in India for serving US tech companies from India? And if so, why? And do you have any suggestions would you offer to recruitment companies already in contracts with US companies to navigate these changes?
Yeah. So it's a very good question. So you're saying that you have companies in India who are getting into contracts to service US companies, right? Is that the
Yeah.
question? Okay.
Yeah, I think.
Okay. I think having the documentation, right? Like, so what if I were to negotiate a contract today with an end client? And if I know that I'm going to use H-1B personnel on that contract, right? Right when I'm negotiating the MSA, to the extent possible, if I can put in some language stating that for these positions, these are the high level job duties. You don't have to get too granular. And these positions will require a bachelor's degree in a field logically related to these job duties. If you could put that language in the MSA itself, all right, I think that's going to go a long way because then you don't need client letters for each and every position. Again, depending on how you wordsmith this in the MSA itself, you can then rely on this MSA, which typically doesn't change for years, to get the H-1Bs approved.
Mhm.
So that
Yeah.
was a good question, but and again, we can talk about this, in more detail via email. So I think that's
Oh,
it. I think we've gone over. In closing, I think let's don't freak out, right? Get competent counsel, sit down with your attorney, figure out a way forward, focus on proper documentation and compliance. If you do that, I think you'll be in good stead. And if you have some very key employees, be ready to litigate their cases in court if they get denied by USCIS, right? So, and this could be another seminar on federal litigation because I've done a lot of it. It's all about how you structure your petition, to be honest, right? So the more time and effort you put in preparing the petition, the easier your life will be down the road.
Okay, thank you so much, Vinay, for sharing your insights with our today's webinar. And for those who are interested of rewatching our webinar, this will be available on our YouTube channel. So please subscribe to our YouTube channel, and we will also be sending some emails for this today's webinar. Thank you so much,
Great.
Vinay.
Thank you.
Have a
Thank
great
you.
day, everyone.
Thank you. Bye.